right, so let's start our third panel and really finish the afternoon off with three more outstanding participants and presenters. You might have seen me looking a little stressed a couple of hours ago. One of our programmed panelists for this session, Adina Likovich, who is with the Muslim Political Affairs Council, became ill today. And I guess about 1 o'clock got a message that she just was not going to be able to get over here, which was very, very disappointing. So fortunately, I have a student who is friendly with her and does a lot of work with MPAC. And we got on the phone very quickly. And Adina is the head of policy and planning for the Muslim Political Affairs Council. Instead, we have the president.
Sorry about that.
Thank you. Salam Al-Marayati got in his car, headed down Wilshire Boulevard, and agreed to fill in for Adina. Thank you so much. Thank you so much. We also have, as a panelist and moderator, Katherine Stern from the Constitution Project. And as you may have read in your bios and acknowledgments, the Constitution Project is a Washington-based nonprofit organization dedicated to the nonpartisan study and examination of constitutional issues. And Katherine is the senior counsel with the Constitution Project, and she's come all the way here from Washington, missing the dinner last night, I understand, which they had their big gala dinner last night. But Katherine, thank you for coming all this way to be with us. Really appreciate it. And our last panelist is Chris Edelson, who is a professor in the government department at American University. I used to live about 3 blocks from AU and run the track there. So Chris is an expert in presidential power, presidential war powers. Earlier, his new book on emergency presidential powers and terrorism was on sale when the bookstore representative was here. So we have 3 great people to finish off our conversation today, looking at the civil liberties implications of the war on terror and the balance between privacy and national security. Katherine, take it away.
Thank you, Cindy. It's wonderful to be here and to see all of you here, all of you so interested in this incredibly important subject. I'm going to just begin the conversation by raising some preliminary questions about the topic that Cindy's given us. The whole idea that we need to think about terrorism and counterterrorism in terms of war, and the idea that we are at war. And then I will turn the conversation over to Chris Edelson and Salam Al-Marayati, and they will speak and have about 10 minutes of comments, and then I'll give them some further questions and then open it up for everyone else to join in with questions. As Cindy said, I work for the Constitution Project, which is a think tank and advocacy organization. And one of the things that we do that's quite unique and effective is that we recruit bipartisan committees of policy experts, former government officials and legal practitioners from across the political spectrum to come together to foster consensus-based solutions to some of the most difficult constitutional issues of our time. And I wanted to just mention that since we've been talking about this earlier today, I just filed comments with the Privacy and Civil Liberties Oversight Board on the NSA's collection of U.S. persons' emails and online address books and other communication data under Section 702 of FISA. That's an authority we haven't had a chance to talk much about today, but you might want to look at that. And we're also coming out with a report on reform of the FISA court, the Foreign Intelligence Surveillance Act court, and on the special advocate proposal that Cindy Cohn mentioned in her talk at lunchtime. But with these last two panels, we've been expanding the conversation beyond privacy and warrantless surveillance to include other threats to our fundamental freedoms, threats to life and liberty, in fact. For example, targeted killings and indefinite detention without charges. So, for example of how war is invoked to justify these things, in October of last year, the Senate Judiciary Committee held a hearing on NSA surveillance, and Senator Graham was questioning Keith Alexander, NSA's director. And General Alexander was asked, are there actions to penetrate the United States? And I should say at this point that Senator Graham was getting a little frustrated with the fact that it had become clear that the NSA really could not justify its collection of telephone metadata. There was no example that General Alexander or Director Clapper could come up with to show that this program had been effective. So Senator Graham wanted to resuscitate the program. At the very end of the question, he came in and said, are there actions to penetrate the United States? And General Alexander answered, there's a sleeper presence. He said, I wouldn't call it a unified fifth column. So Senator Graham took it further and he said, are we at war? And this is the battle cry of the intelligence community and the counterterrorism community. Are we at war? And General Alexander said, I do believe it's a war on terrorism. And then he said, and those are my words. But he went on to say, to try and show that there is a war on terrorism and a threat, he said there were 972 people killed last year in terrorist attacks in Kenya, Yemen, Syria, Iraq, and Afghanistan. I'm not sure that those numbers are accurate, but then he also said, and over 1,000 injured. Those numbers sound actually pretty low to me. But he did indicate that because those terrorist attacks are occurring elsewhere, we need the tools to keep our country safe, he said. So I don't want to suggest that there isn't a threat and that there isn't actual reason for concern for domestic attacks on a massive scale are a possibility, and we certainly do need to address them. But what I wanted to raise is, what are the implications of looking at the possibility of a massive attack on civilians as an act of war as opposed to a criminal act? And what does it mean when we invoke wartime and the whole framework of war when we talk about the threat of terrorism? What's at stake in applying the war paradigm? And I want to just make 4 simple points about that, about the difference between looking at counterterrorism as being at war as opposed to law enforcement. First of all, there's no defined battlefield, so no geographic boundaries. That's very significant. When you're on a battlefield, there are exigencies of the battlefield, and there are all sorts of traditional legal understandings that come out of that. But we don't have a defined battlefield in the war on terror. And second, we don't have a defined time period. This is perhaps even more disturbing. That there's no temporal boundaries means that you can, at any time, evoke a permanent state of emergency. But note too, let me go on to my other 2 points, that the decisions to authorize and carry out torture or enemy combatant detentions or targeted killings, that those are routine executive branch decisions that are made by administrators and bureaucrats sitting at desks far from any recognizable battlefield and without any of those exigencies of the battlefield. So when we are in a we're at war mindset, what we have done to our ability to think about civil liberties, I would suggest, is that we have given up a very modern and evolved framework, the civilian criminal justice framework, for one that's ancient and primitive. Now, it's true that the law of war is made up of certain modern elements. Of course, it has the very old common law of war elements, as well as more modern treaty-based elements, and it also has the military criminal justice U.S. guidelines that are certainly modern. But basically, at its most fundamental, the law of war involves a sweeping disregard for individuals, for individual circumstances. It's about nation versus nation. And so what you give up when you think in terms of law of war is you give up a modern Enlightenment era focus on fact-finding. The law of war actually predates scientific thinking, and it predates thinking about individual rights. So you give up procedural safeguards, and you're thinking, instead of individuals and thinking about individual threats, you're thinking about massive retribution. Now, I know that there is a criminal law of war, and I don't mean to be reducing it that much, but I did want to make this sort of broad brush distinction that often we heard in the wake of 9/11, we heard government officials saying, well, we can look at this through the law of war, we can look at it through the criminal law, and we have these two different paradigms available. But think about which one is more modern. We didn't have our first guarantee of criminal procedural safeguards until 1696. That was the treason statute that our founders actually modeled the Sixth Amendment on, the 1696 treason statute. And it's important to think about the modernity of individual rights and how important they are, especially when we think about the way the law of war impacts ethnic and religious groups, minority groups in this country. So this is my last point, is that not only is the law of war more ancient, more primitive, but it's also, the law of war is a paradigm that has to do with massive and often indiscriminate violence against a distinct, identifiable group of people. And that group of people has been pre-identified. In other words, you need to know who they are ahead of time in order to be at war against them. So they have to have characteristics that you can consider enemy characteristics. And this is important. So when we think about, is there a war and are we at war? We are also asking, is there an enemy, and what does the enemy look like, and how do we know who that enemy is? And so with that, I will turn to our speakers. And first asking Chris, is there a wartime constitution? Is there an emergency constitution? And how far does the president's inherent Article 2 authority go?
Excellent question. So Katherine's group, I have a great deal of respect for, partly because of the excellent work she's talking about. She's doing the comments on the PRISM program, this really troubling program, and this ideas about reforming the FISA court, which I think are really important. Also because they have a fellow associated with, I think he's a fellow, right? Lou Fisher?
He's our scholar in residence.
Scholar in residence, sorry. Lou Fisher is a legend in the field of presidential power. And the reason I called my book Emergency Presidential Power is because he already had written a book called Presidential War Power, which is just a magisterial work. Otherwise, I would have called it that, but I couldn't rip off his title. He wrote the foreword to my book, which I was very honored by. What he maps out and what I tried to pick up on is this idea of what is presidential power like during wartime or crisis, even if you claim that there's an emergency or threat to the United States, it's not a war. And there's, I think, a dangerous tradition that Lou Fisher has identified and that I think, unfortunately, when President Bush left office, I think there was an opportunity to move away from this. Cindy mentioned that your perspective on what's been going on since September 11th might be influenced by where you live. Certainly for me it was. I was in New York City on September 11th, and I was really scared. I was scared for a long time. I was scared there would be, just every day there would be suicide bombings, all kinds of things would be going on. I realized that it was important to maintain perspective, and that one thing terrorism tries to do is to make people afraid. It does a good job of that, but it's important to keep that in perspective. But it also made me wonder, after I kind of regained some perspective, there are these claims the government is making. The Bush administration started to make claims, and I wondered about them. They claimed they needed all this authority. Some of this was not known about immediately because these claims were made in secret, claims about, Katherine mentioned, inherent power. There's this idea, John Yoo, have people heard of John Yoo? John Yoo's kind of the face of this, although I think he serves sort of as a fall guy for Vice President Cheney, who really was pushing this since at least the mid-1980s. John Yoo, as a lawyer in the Office of Legal Counsel, Katherine mentioned bureaucrats sitting around. This always gets me with him. And I don't mean to suggest he's a Nazi or Bush is a Nazi or Cheney's a Nazi. Only the Nazis were Nazis. But John Yoo was this bureaucrat sitting in an office. I work in Washington, D.C. I walk past he was in the Office of Legal Counsel in the Department of Justice, right near the National Mall. I go there all the time with my 4-year-old daughter and her 4-month-old boy. And he was sitting in that office, and he wrote these incredible memos that were secret for several years that made a claim, what's called the unitary executive theory. And basically, the unitary executive theory says that when the president is exercising powers as commander-in-chief during wartime, presidential power is essentially unfettered, that Congress cannot pass laws, whether it's the Foreign Intelligence Surveillance Act or the Anti-Torture Law or the authorization for the use of military force, that limit presidential power in any way in these areas when the president's exercising executive authority, because the president has inherent authority in these areas. Inherent authority essentially means unchecked power. It's a really dangerous notion that I think is antithetical to constitutional democracy. The framers of the Constitution made a number of very serious errors, chief among them slavery, the Electoral College, the way senators are assigned. They did a lot of things wrong, but they got some things right. And one thing they got right was to break with the British model, which at the time meant the British monarch had prerogative, unfettered power in a lot of areas, including over war and peace. John Yoo's unitary executive theory, really Vice President Cheney's, but John Yoo wrote these memos spelling it out, act as if the British model was put in place by the U.S. Constitution, that we have this monarchical model for presidential power. And he used it to justify things like torture, waterboarding, sleep deprivation, violating criminal law, this warrantless surveillance program, the presidential surveillance program, which included among it the metadata program, which has continued since then with authorization from the FISA court, but initially did not. And also in a September 25th, 2001 memo, John Yoo said, when we're talking about military force, these decisions are for the president alone to make. Congress can't limit the president. So these memos became public eventually and were really, pretty shocking. President Obama, when he ran for president in 2007, 2008, said, I think rightly, President Obama has a background as a constitutional lawyer, a constitutional law professor, and he said, that's wrong. Bush administration was violating the rule of law. We have to set this right. He had a number of advisors, including Harold Koh, dean of Yale Law School, who said the same thing, and it sounded great. They took office, and I figured, hey, we're going to move in a different direction. Unfortunately, the next book I'm working on argues that in a number of ways, the Obama administration has continued this approach. They have not adopted the unitary executive theory, so it's a little bit subtle. On the surface, you don't see this. John Yoo's language, the president is unrestrained, has plenary power, is the sole organ of the nation when it comes to foreign affairs. All basically arguments for unchecked power. The Obama administration typically does not make those arguments. What they do instead is they find more creative ways to reach the same conclusion. The president cannot be limited by statutes. The president can do what the president wants during wartime to defend the nation. For instance, one example is the metadata program. When you read the report, Katherine mentioned the Privacy and Civil Liberties Oversight Board. I always forget their full name.
That's right.
Yeah.
You got it.
They go into depth about explaining how this program was justified. And it made me think, I'm a lawyer by background, it made me think of money laundering. This original program was done in secret. It did not receive approval from the FISA court. Eventually, once it became publicly known about, there was approval from the FISA court that gives it a patina of legitimacy, but it was based on a completely implausible reading of the statute that every call Americans make or receive within the United States is relevant to an investigation. As the Privacy Oversight Board report concluded, basically the logic was because terrorists use phones, any phone call that is made in the United States is relevant to terrorism. It's utterly implausible. It gives unfettered power. This is the argument that the Obama administration made and succeeded in convincing the FISA court to accept. It's not limited to privacy. It's striking the way it's used in that context, but it's actually part of a pattern. The Obama administration, when it comes to the use of military force in Libya, Syria, even Ukraine. On the plane over here today, I was reading in Ukraine, Secretary of State Kerry said, "We are ready to act." What does that mean? That means that the president is going to order military force without Congress approving it? Unconstitutional. It's happened, of course, many times, of course, since the Korean War, including in Libya. But that doesn't mean it's justified. But the Obama administration, even though it doesn't use the language of the unitary executive theory, reaches the same conclusion. When it comes to where the president can act, that was the Obama administration's position in Libya. It was their position in Syria, even when they backed off. Last summer, you remember Congress, about 200 members of Congress sent letters to the Obama administration and said, you better not take action in Syria. Obama seemed to back away, and he said, okay, I will let Congress vote. But he said several times, I reserve the right to act, regardless of what Congress does. If Congress had said you cannot act, he said, I'm prepared to act anyways in defiance of Congress. And in Ukraine, he seems to have the same approach. I'll just mention one more example. The targeted killing program of U.S. citizens. Anwar al-Awlaki, his son was killed, 16-year-old son Abdul Rahman al-Awlaki. Not exactly clear why. Anwar al-Awlaki was targeted. Samir Khan was also killed in that drone strike, U.S. citizen as well. The justification for that program is simply implausible. If it were John Yoo justifying it, he would say the president can do this because the president is president. President's commander-in-chief, president has plenary power. The Obama administration does not seem to have said that. And I say doesn't seem because there's a secret memo justifying this that has not been released. But what they say reaches the same conclusion. They find a way to read statutory and constitutional provisions in an implausible way, including Attorney General gave a speech where he said, so one of the arguments, Anwar al-Awlaki is a U.S. citizen, not a sympathetic figure, clearly involved with al-Qaeda in the Arabian Peninsula, at least as a propagandist. But the government's position was he is an operational leader planning attacks against the United States. We have to kill him without a hearing or trial. His father, Anwar al-Awlaki's father, filed a lawsuit and said, wait, he's a U.S. citizen. Under Hamdi, if you're going to detain a U.S. citizen, you've got to give a hearing. If you're going to kill him, you've got to do at least the same thing. The Obama administration's position, Attorney General Holder explained in a speech at Northwestern Law School in 2012, is Hamdi requires due process. It's true before you detain a U.S. citizen, and we think that's the same for killing him. But due process does not have to be judicial process. Which is, I don't know what that means. I mean, it's inconceivable. In the Hamdi case, the court said the point of due process is that it sets limits on the president, checks and balances, separation of powers. The things you hear about growing up, you figure, oh, everyone takes this for granted. It turns out they don't. The Bush administration didn't take this for granted. The Bush administration argued that separation of powers, checks and balances do not constrain the president. And I'm concerned that the Obama administration has reached the same conclusion in a number of areas, including privacy. So I'll stop there, but please.
So how do we deal with the disparate impacts of these policies? And also, I think a more fundamental question is, what are those disparate impacts? We really we need to understand as a people, in order to have a real referendum on this, in order to have real democratic process about it, we need to understand who it's affecting and how. And is that information out there? Do you think that that Americans understand how these policies have been affecting Muslim Americans?
Well, yes and no. I think to some extent Americans understand the impact of these policies on American Muslims because it actually has affected all of us. When there is surveillance, it's not just surveillance of American Muslims, it's others. When there was I forgot the name of it, but the the program where immigrants had to register. It was some registration program.
Yes. I don't know the name either. But yes.
Right, and so when we used to have an INS in downtown Los Angeles, they had certain countries that were designated where people with who were non-citizens had to go and register. And I remember there were countries that were lobbying to take their countries off the list. So, for example, Armenians did not have to register because they were able to successfully take Armenian immigrants from off that list. Obviously, people from Saudi Arabia and Egypt had to register. And so the impact of that, number one, the program was rendered ineffective. However, some men were taken to Lancaster, and their families didn't know where they went. So that definitely had an impact, an immediate impact. And we developed a human rights monitor campaign where we would try to talk to families whose family members disappeared. And this is interesting because this is reminiscent of what happens in the Middle East. When the police knock on your door, that usually means someone is going to disappear. So it had a devastating effect on that community. And that was back in, I believe, 2002, 2003. Later on, I think as the programs, the other program, obviously, for us is Guantanamo. Because even though it was a handful of people, I was actually asked to visit Guantanamo. I made it out. But I was asked by the Pentagon to go and assess Guantanamo. And we went, we could not talk to the inmates. But what the Pentagon was trying to show us was, look how we're feeding our inmates, and they were overweight. And look how we're giving them Qur'ans and prayer rugs and cleanliness. But what I noticed is that the inmates were walking back and forth like nervous animals in a zoo. So that image alone is, aside from obviously the impact of these individuals and their families, but the image of that this is what is happening to Muslims who, many of them were in the wrong place at the wrong time, was devastating. They asked me, so what do you think about our operation afterwards? Because they wanted to impress us on how great of an operation it is, because they were so humane with the inmates. I said, it's like a doctor going into an operation. They asked him, how was the operation? He says, the operation was a success, but the patient is dead. So you can do whatever you want, but civil liberties, our ideals, the idea of an open society, what happens when you're in a wartime mentality for this long, and now it's technically the longest war in American history, without knowing who the enemy is, without knowing really what the extent of an enemy that is not a country. So it presents us in the Muslim community with very complex problems. And the other problem of the American Muslim community is that we don't have the capacity. We are at the stage where Mormons were in the 1800s, or at the stage where American Jews were in the early 1900s, or at the stage where Catholics were 2 centuries ago. We are in our nascency. We don't have a PR firm. We don't have a lobby. We don't have TV shows. We don't have much. So there are 3 strategies that have taken place within our community. The strategy is, for some Muslim organizations, is litigation. Let us get together and litigate our way through this problem. Another strategy is, let us just start chronicling all hate incidents and hate crimes, and if we have to deal with law enforcement, they only come for that purpose. Come and support us against hate groups. Defend us against hate groups. A third strategy is partnership. In other words, we tell the government and we tell law enforcement, you either treat us as suspects or you treat us as partners, but you can't have it both ways. And so that third strategy is what my organization is employing at this point. That yes, there is a problem, because also for us as American Muslims, we're dealing with these policies on the one hand. On the other hand, we are dealing with recruiters of violent extremists that come into our mosques, and young Muslim men who are either psychotic or who have an identity crisis fall prey to them. And that has taken place in a handful of cases. There are a handful of cases. Somali immigrants in Minnesota, Tamerlan Tsarnaev in terms of what happened in his lifetime, things like that. So we have to deal with this issue on the one hand very effectively but very delicately, and it's very tough to do. And I know we did a documentary. It's called the Newberg case. I don't know how many people are familiar, but it's basically an entrapment case, and you can't argue entrapment. I don't know, Chris, if you agree with me on that or not. But anyone who tries to argue entrapment in some of these government informant cases, they've lost in the post 9/11 era. Before I go to Newberg, what happened in Irvine was interesting. I don't know if you followed what happened in Irvine some years ago. There was a person that was trying to recruit people for violence to go and fight the American army or fight America. And the community and the mosque leadership reported that person to the FBI. Later to find out the person was an FBI informant. So we deal with these paradoxes over and over again. So you can imagine what it's doing to the psychology or to the spirit or the morale of our community. Anyway, so we did this documentary, and I'd like to say my fellow actor, Mike Trimman, was in that documentary with me. Mike, I hate to do this name dropping, but I'm on a university, so I might as well. But we were in this documentary about the Newberg case, where it was a clear entrapment case, but the guys did not win. And what's more alarming is that the government called this an international conspiracy. It was basically impoverished people that were lured in by a guy who was given hundreds of thousands of dollars to get them to do criminal activity that had nothing to do with terrorism. They were not part of Al-Qaeda. They were poor people. Criminal, yes, maybe, but definitely not terrorism. And yet it was reported as the government foiled another international conspiracy terrorist case. And hopefully this documentary will be shown to force reform of law enforcement. Anyway, there are other things I'll leave for the question and answer period I want to talk about. But in general, when we talk about civil liberties, then, what we are working for are four important goals, towards four important civil liberties goals. One is constitutional policing. That, yes, we need policing, but it has to adhere to our Bill of Rights. It has to adhere to some level of transparency and definitely some accountability. You cannot let law enforcement or the White House or any of these government agencies have absolute powers in these cases, so there has to be reform that adheres to civil liberties. So we engage police. We engage William Bratton here in LA, and he went to New York, and he dismantled the demographics unit, which was basically the group that was conducting surveillance on Muslim communities. And it turned out there wasn't a single lead from that group, which is another issue, which is a waste of taxpayer dollars. But they visited the best Middle Eastern restaurants and enjoyed the best foods in New York, which is what they spent most of their time doing. But I have to give credit to Chief Bratton for that, for dismantling that unit, and I believe that he will help in moving NYPD back towards some level of constitutional policing. Number two is freedom of movement, and what I mean by this is that when we go and travel and come back, there are a number of cases where American Muslims, South Asians, and by the way, the case of the national registration of immigrants, it didn't just affect Muslims, it affected Persian Jews, for example, or anybody that was quote-unquote Middle Eastern looking, which to this day I don't know what that means, other than it means a person of color. So it doesn't just affect Muslims. So freedom of movement is when we travel and we come back and we are harassed at the border as we come back to our home country. So freedom of movement is an important civil liberties goal. The third is freedom of association. In other words, if I'm running a charity and I work in the Palestinian territories, or I work in Afghanistan, Pakistan, I am actually working to serve American interests. But if I have the government shutting me down because they have to build a case to show Congress, look how many charities we've shut down in the war on terror, which does, again, didn't mean a single thing in effective counterterrorism strategies, then this is guilt by association. But because my roots are in that region, therefore I'm a suspect, and therefore the money that is being raised in our community to do that work, it's not for American interests, it's against American interests, through guilt by association. And usually, in these cases, it's you're guilty until proven innocent. The fourth is not a government problem, it's a problem involving non-governmental actors, which is the freedom from intimidation and fear. And that is the industry of fear-mongering that we see, unfortunately, on talk shows and the media that reinforce these policies, that lead to more aggressive and confrontational policies towards a community that really not only had nothing to do with 9/11, but if anything, they are the answers or the antidote to Al-Qaeda's propaganda. Al-Qaeda's nightmare is to have a well-integrated American Muslim community that is upwardly mobile, that is succeeding. They want to see, their narrative is America is at war with Islam. And unfortunately, a lot of these policies are reinforcing that propaganda. So our strategy is to engage law enforcement, to have partnerships with them, and to force the issue, treat us as partners or suspects, and to pursue these civil liberties goals.
Salam, I want to ask you about the opposite of war making. What about peace and the goal of using ethnic and religious organizations and interfaith dialogue to advance peace goals?
It's an excellent question, because this takes us away from civil liberties, and now we're looking at the issue of religion. And I mentioned there are people who prey on our young Muslim men. There's definitely a group of Muslim extremists that have spawned from war-torn areas that have no central government that has any authority. There are gangs, and so they use Islam as their banner to support violence. Another way of looking at it is a form of religious nationalism, that to get political power in Egypt, for example, the Muslim Brotherhood uses Islam to get power and then impose what it thinks is in the best interest of the people. It is not Islam, but it is what they use to gain power. It's a form of religious nationalism. Al-Qaeda is the worst form of religious nationalism in the sense that that religious nationalist ideology is violent and destructive. We obviously have religious nationalists here as well. There are 100 white supremacist cases after Oklahoma City. And there are religious nationalists in the occupied territories that are taking Palestinian lands, and they are supported by an ideology and by using religion. So there is a problem in all religions of religious nationalism. It's not just bigotry. It's a form of fundamentalism that uses politics with the validation of religion to justify their anti-human practices. So you have people who use religion as an instrument of war. What we're trying to do in America is to work with Jews and Christians and Muslims to develop an Abrahamic faith peacemaking initiative that says we are working to looking at religion as an instrument of peacemaking, because we believe this is what God has willed upon us. He has willed that we're all different so that we may, as the Quran says, to learn from one another, not to despise each other. And that is what we are taking from our texts. Yes, an extremist can take anything from the text and say, oh, this is religion. But the silent majority of all of our faiths, Judaism, Christianity, and Islam, have to work now to present that peacemaking model within the framework of religion. Because people think that, oh, I have to depart from religion to be nice to you, because you are not a believer. right? But it's the exact opposite. When you read the texts and you read the messages of Jesus and Moses and Muhammad, it's exactly the opposite, because what they came for, in my opinion, in our teaching, they came for human dignity and human equality. That if you believe in one God, you have to believe in one human family. And that necessitates a work towards human equality. This is the theology, if you will, of our peacemaking initiative. And we think that that narrative is important to get out there, because there are stereotypes of Islam and Muslims, but there's also stereotypes of religion. And by the way, we believe that religious nationalism is the major threat to religion, not secularism. Secularism actually allows for religious prosperity or flourishing of religion, religious expressions. But religious nationalism disfigures religion, and it leads people to leave religion. So it is the major threat to us.
Wonderful. Chris, when Salam talks about constitutional policing and how the government cannot have absolute powers, and describes these programs where there's completely an inaccurate targeting and profiling of people, it makes me think that there's really a very basic problem here of the government claiming the right to be inaccurate. And I think it goes back to this issue of the war paradigm versus law enforcement. In war, the government does have freedom to be inaccurate. It doesn't have to be right. It just has to have the right motives in attacking. But in the law enforcement paradigm, there's supposed to be redress. There's supposed to be due process, and you're supposed to be able to actually prove your innocence. So what does transparency have to do with all of this? How can we have accuracy if the government has no accountability and no transparency in its programs?
Yeah, I mean, I think it goes back to what Mike said in the last panel, and Salam has made this point too. The uniting threat, whether you're talking about wartime or using military or police, the rule of law applies and sets limits on power. And as Mike said last time, if citizens don't have information about what's happening, they can't possibly fulfill their responsibilities as democratic citizens and play a role in limiting power of police, military, presidents. The history shows us that, of course, there's a need for secrecy. The framers recognize this. Of course there is. There's a need for secrecy. But history also shows that when presidents act in secret, a lot of times really bad things happen. President Nixon springs to mind, of course. That was, as basically a secret criminal enterprise set up within the government. President George W. Bush, there was a lot of secrecy. The memos I was talking about, where John Yoo was writing these secret memos, and reminding me of Hannah Arendt's phrase, the banality of evil. Again, not that he's a Nazi, but that there are these secret things going on that law professor Scott Horton said we didn't know it, but from 2001 to 2009, we were living in a dictatorship. I think that's a little much. I don't agree. But his central point is there were these arguments made about presidential power that we didn't even know were being made that justified setting aside criminal law. So President Obama, again, comes into office and he says, this is going to be the most transparent administration in history. It's a laudable goal. Unfortunately, once again, to fit, this is sort of self-serving, fits into my theme. President Obama, there's a gap between his rhetoric and his actions. And that rhetoric is great. Restore the rule of law, bring back transparency. In practice, it hasn't happened. I mentioned there's this secret OLC memo that justifies the targeted killing program. There's no reason, Lou Fisher makes this point very effectively, there shouldn't be secret law. Intelligence gathering, of course, there's secrecy involved in the kind of Mike mentioning undercover work. Of course, there are legitimate reasons for secrecy. When you have a law that's secret, though, people don't know what the law is. So that can't be justified. The Obama administration has used this very dangerous doctrine called the state secrets privilege, which goes back to the U.S. versus Reynolds case in 1953. Bush administration used this. Obama's continued it. And basically what it means is, to one central example, the extraordinary rendition program, which was used to take people and send them to the countries where they were horribly tortured. One case, the Jeppesen case, Mohammed versus Jeppesen. Jeppesen is a subsidiary, I think, of Boeing, if I remember correctly. I think that's right. And Jeppesen was, their planes were used to bring men to countries where they were tortured, horribly tortured. The things that happened included electric shocks on genitals, a scalpel used to cut incisions in people's bodies, and hot liquid was poured into it. This lawsuit was broad, and it raised some really important and troubling issues, many of which were covered by Dana Priest, who Cindy mentioned before. She did some really excellent reporting on this for the Washington Post. The Obama administration said, sorry, we can't allow, this claim can't go ahead. It wasn't even brought against the government, but the government had intervened under the Bush administration. President Obama said it can't go ahead because it would expose state secrets. And the Ninth Circuit, in an en banc decision, 6-5, said we can't take the risk that state secrets would be exposed. The dissent, I think, really trenchantly and correctly said you're deferring to presidential power. The state secrets privilege basically gives the administration a way to hide embarrassing things and not have to litigate them. And when the president raises a claim of state secrets, you should allow the litigation to continue. Don't dismiss it, which is what the en banc court did, but allow it to be litigated. And if real problems come up, you can take care of them when they do come up. So I think without information, democracy doesn't work. President Obama, I think, rightly promised to restore transparency, but the unfortunate reality is it doesn't always happen. It hasn't been happening.
What about no-fly lists? We haven't talked about specifically about what happens when individuals are put on a list and they're not allowed to get on a plane, to return to the U.S. or to leave the U.S. Does your organization work on this issue specifically? What's your experience with it?
I mean, we really don't work on specific cases. We work on policies, but there are a number of groups that do. However, we have a government relations office that can run things up the pole, if you will, and talk to people within the Department of Homeland Security or the FBI about those cases. And definitely there have been a number of cases. One of the policies that we helped develop and implement is called TRIPS, where people can apply, and if there is a case where there's a mistaken identity, in other words, if I have a name that is similar to a name that's on the OFAC list, a group of designated individuals you can't do business with, that is established by the Treasury Department, and if my name is close to any of those names, we have people apply to TRIPS program so that it's clear that there's not going to be any mistaken identity in terms of limiting their travel. That would limit their travel.
I noticed a real discrepancy between the conversation that we had at the beginning of the day about privacy and about the enjoyment of withholding information about yourself from the government. And this conversation here, which is all about, because we're dealing with the problem of government inaccuracy, having to offer information about yourself in order to clear yourself of suspicion. I wonder what our panelists would say and what other people in the audience would say. I'd like to open this up about the right to anonymity. We've asked whether there's still a meaningful privacy in this country. Is there meaningful anonymity, and is that a right? Is that important to us?
Probably.
I mean, I hope so. Justice Brandeis famously said in the Olmstead case in the 1920s, the most important right, I'm not sure if he's right about this, but it is an important right. The most important right, he said, that the framers created was the right to be let alone. And in the context of metadata collection, this report by the Privacy and Civil Liberties Oversight Board, and also Judge Leon's opinion in the D.C. District Court a few months ago, made this point. They said, hey, if you are participating in modern life, there's certain things you have to do to participate in modern life. I don't even know why this is funny, but I have this flip phone. People think it's, I hate phones, but you have to have it, right? I had no way around it. My wife said, you got to have a cell phone. Right, okay. You have to have cell phone. You have to have some kind of credit or debit card. This is a real problem for people in many circumstances with low incomes. And by using these things, by using a phone, by using a credit card, that shouldn't, I think, in this Privacy and Civil Liberties Oversight Board, I think, rightly made this point, it shouldn't mean you expose everything to the government. There's a doctrine from the Smith case in 1979 the Supreme Court decided, and they said the third-party doctrine. If you make records available to a third party, like in this case, a phone company. They have the numbers you're calling. That means you don't have a reasonable expectation of privacy in that information. That doesn't make sense to me. Maybe in 1979, I'm not sure even then, but certainly not in 2014. If I make credit card purchases, if I go to a store and use a credit card, of course I know the store is going to use my credit card to process it. That doesn't mean that I expect that they're going to give that information to the government. I think I do have a reasonable expectation of privacy in that. So I certainly hope there are limits. It worries me, about what it means in reality, but I hope so.
50 years from now, if a government of the United States wants to make massive arrests and detentions without charges, will it have a basis for doing so by looking back to the law now? Will it be able to find precedent and justification in our current law for taking people from their homes and detaining them without charges indefinitely 50 years from now, if there's some motive for doing that then that we can't anticipate? Does the law let them?
Right. I forgot which, I think it was an Antonin Scalia who recently was speaking to a group, I don't know where, but they were asking him about Japanese internment.
Yeah.
And he says, yeah, it was wrong, and it was, I don't know if he even said it was wrong. I think he basically said, unfortunate or something like that. And then he said, but don't fool yourselves. It could happen again. This can happen.
Yes.
Now, I'm not a lawyer, but no offense to this body, but in speaking to Japanese Americans, the lesson is, regardless of whatever the law is, or whatever the government's going to do, there are 3 lessons from Japanese internment. Number one, you had a catastrophic event that led to hysteria. So hysteria, it should be somehow countered with reason, with rational thinking, with responsible political leadership. I know that's asking for a lot, but you should work for that. Your civil society, and there's somebody who said the Bill of Rights is nothing without civil society pushing for them. Maybe Chris can inform you who that great person is, but it's a great point. So hysteria. Number 2, prejudice. When there's prejudice, you stigmatize a group, they become isolated, ghettoized, they're easy to target, and so you're dealing with that problem of prejudice. And again, effective strategies in countering that. The third.
Oh, sorry, go ahead. No, go ahead.
Yeah, I'm sorry. The third is when your institutions representing your groups have no alliances, have no partners, have no say in the current society. And American Muslims are dangerously at the level of all 3. A catastrophic event can lead to that. Is it going to be internment camps like we did? And again, Scalia reminded us, Korematsu justified internment because of what? National security.
Yes.
You invoke national security, then all bets are off. You can do so many other things. So, yes, we are in that. It may not even be 50 years. We are one catastrophic event away from that. Unless we, as American Muslims, work effectively on all 3 fronts to demonstrate that we are part of the solution. And I don't mean that we have to validate ourselves or we have to prove ourselves. No, but to be involved in effective strategies. For example, the Boston Marathon and Tamerlan Tsunami. There are a handful of these kids, unfortunately. And so what we've formed is what's called safe spaces. Safe spaces so that our mosques are safe from violent extremist recruiters and from government informants. To have the spiritual safety and the sanctuary of our mosque not violated. And then working for public safety, because of course all of us want public safety. But it's not going to happen through all these great programs like Congressman Peter King is talking about when he says every mosque is a source of radicalization. So we're working towards that in terms of being rational. Prejudice, obviously, there's bigotry, and you just turn on any talk show, unfortunately, or any there's an industry now, $43 million industry of groups that are out there just to promote prejudice against Muslims, just to say Islam is evil, we're at war with Islam, or they say radical Islam to make them to hedge, even though people don't know what the difference is between Islam and radicals. It's just Islam. And then the third, in terms of partnerships and alliances, to build Muslim institutions within civil society that deal with all these issues. And that's what we're working on.
Can I just make a quick point about that? I think Salam is absolutely right to cite the Japanese American internment example. Fred Korematsu, who died a few years ago, filed an amicus brief in the Rasul case, which involved non-citizens held at Guantanamo. And of course, Guantanamo is not the same as Japanese American internment. There are differences. But Fred Korematsu's point is there are similarities. And one of the important similarities is people were being held and still are being held without a trial. Korematsu itself has never been overruled, partly because it's the first case that recognized strict scrutiny. But some contemporary judges, Chief Justice Rehnquist wrote a book about, I think, 1998 about war power. And he said, Japanese American internment was not justified for U.S. citizens, which about 2/3 of the people put in camps were U.S. citizens, like Fred Korematsu. But for the non-citizens, it may have been justified. That's a stunning statement. There was no evidence that any Japanese American, citizen or non-citizen, was disloyal. None. It was absolutely fabricated. It was partly the government felt, Mike suggested this idea, when something bad happens, something dangerous happens, and obviously did. Pearl Harbor was a real threat to the United States. Japanese warships really were operating off the west coast of the United States. The government felt the need to do something, but it lied to the court. It said that there wasn't time to separate disloyal from loyal Japanese Americans. It knew there were none. So in response to this, in 1971, Congress passed a law called the Non-Detention Act, which says no U.S. citizen can be detained except pursuant to a law passed by Congress. That was supposed to prevent another mass internment. Two big gaps, though. It only says U.S. citizens. And secondly, it says pursuant to an act of Congress, it's okay. The Japanese American internment was actually ratified by Congress. So I don't mean to be alarmist about this. I think it's all right there. Guantanamo is not Japanese American internment, but right. It's a really, unfortunate to put it mildly, repeat, as Fred Korematsu said, of this idea that you can hold people without trial. And I think, as Salam points out, it's just a question of, if something bad enough happens and there's an argument this is necessary on a larger scale, I worry that it could happen, yeah. And I'm not confident that there's a guarantee that it couldn't.
Let me open this up to other people's questions. Come up to the mic. Let's hear what you're thinking about this.
Maybe they're thinking they want to go home.
Yes.
That could be. Well, we've got a few more. Well,
You can always rely on me
Right.
to ask a question.
There they come.
in the few minutes, we have a few minutes left, so let's hear from some people.
Hi, I'm Todd Hood. I've been asking questions all day, sorry. But the question, it sort of rose in my mind. We've been talking about the government and how the government might impact or use data and offend or violate civil liberties. But it just occurred to me that it really depends upon public opinion is how the government gets to do things and that are a stretch. So, and then I started thinking about public opinion, and I know we've been talking about Muslim and Islam, but I started thinking that, okay, it's easy to say, yes, that's wrong when it is a people. Then I thought the difficult decisions might be when we're looking at criminals who have committed a crime and they've paid their time, and then they are still being tracked. For instance, the sex offender registration database, and how no one wants them in my neighborhood and that type of thing. So I started thinking of when you asked the question of could there be a time where people start revolting and taking people out of their homes, and then there were some violations or some crimes that were committed against certain registrants that were in certain neighborhoods and what have you. And I thought, I wonder what your thoughts would be around that, where there's a reason why they're on that registration database, but do they deserve privacy rights?
Do you
Thanks.
want to take a couple questions at
Yeah,
a time?
That's your territory.
Okay. Well, first, on the first point about public opinion, yes, absolutely. And this is not my point. I don't claim originality for this, but a number of advocates have pointed out there is an opportunity with whatever you think of Edward Snowden. And to me, he's not really the big part of the story. The story is the information that's made available. This is an opportunity because public attention is focused on this. Section 215 of the Patriot Act sunsets next year, as it has several times before. Members of Congress will have an opportunity to debate this. And if public opinion influences them, and of course it does, that's democracy, as Mike rightly points out. I think it can matter, and it will be a question of whether, how long will people care about this? Will the press properly cover it? Something that frustrates me. The second point you made about, what to do with criminals and do they lose privacy? Well, that's part of this. People made this point before. You have to separate out. Of course, there are some people really are dangerous. So one of the differences between Guantanamo and the Japanese-American internment camps is there are some real dangerous people there. Khalid Sheikh Mohammed is, someone who is dangerous. He's someone who really was involved with Al-Qaeda. Abu Zubaydah, Anwar al-Awlaki, who I mentioned before, was not an innocent. Does that mean he didn't have a right to hearing, though? I would say no. I think the point is the rule of law has to apply. If whoever you suspect, whoever you accuse, they still ought to have an opportunity, as the court said in the Hamdi case, to appear before a neutral decision maker, have an opportunity to be heard and make their case. Otherwise, that's the whole basis of American justice and the rule of law. You can't assume that people, as bad as they may sound, these guys, I wouldn't want to be, defending Anwar al-Awlaki. It's a tough case, or Khalid Sheikh Mohammed, but I'm glad that someone does. That's if you allow the government to say that these people are already guilty, I think that's dangerous. So I think everyone has rights. It doesn't mean they can't lose them. The Due Process Clause says people, not just U.S. citizens, but persons have a right to life, liberty, or property. Can't be deprived of life, liberty, or property without due process of law. Once it's provided, they can be. But the important thing is providing it. And the troubling thing, one of the many troubling things about recent events is when you give someone no hearing and no trial at all, that the system just kind of falls apart.
And in terms of public opinion vis-a-vis counterterrorism, I think the biggest problem in the post 9/11 era is that law enforcement and government is responsible now for preventing terrorism. And when you tell a government or law enforcement go and prevent it, people's rights are going to be violated as a result. And until we shift public opinion back to this criminal activity is just as bad as that activity, it doesn't matter what religion they belong to or what motivation, it's a criminal activity. There are more people being killed by drunk drivers now than anything else. It doesn't, even though that's not, but when Tamerlan Tsarnaev does that, it's an existential threat. Or when the Newburgh case was made, even though it was a sting operation, the government reported it as an existential threat. So public opinion has to shift back to this is criminal activity. And if we want to deal with ideology, let communities deal with ideology. Government has no business in telling us what Islamic opinion or faith is legitimate and what Islamic faith is not legitimate. So those issues involving public opinion are very important as it relates to legal and governmental policies. And having said that, I want to also say that we do have allies within the government and law enforcement, I believe, that understand this. They don't want to get into this. And that's why the partnership with them is important. I don't want to leave this forum thinking, yeah, government is bad, law enforcement is bad, everything they're doing is bad. But we're talking about how do we make more reasonable decisions, reasonable analyses, rational approaches towards this that are more effective in dealing with the counterterrorism problem, or the counterterrorism, having effective counterterrorism strategies.
We're past 5 o'clock now, so may I suggest let's hear from all of the questioners and hear their questions all together, and then
rapid
take that.
fire.
Yes, so.
Okay, rapid fire. Couple Tim Huanga from earlier. A couple years ago in 2011, there was the case of Humanitarian Law Project versus Holder.
Yes.
In terms of giving assistance to labeled foreign terrorist organizations, and this assistance was to address the UN, seek aid. Do you think the U.S. government is too quick to label, too quick to judge, too quick to say, no, you can't do that when it comes to organizations that might be labeled but actually hold no threat against the United States? That's question number one. Question number two, Jeffrey Stone wrote a book, War and Liberty, which this panel was kind of named after, that we've read in Professor Lebo's course, that stated that the United States has a tendency in history to overreact and then swing back, kind of a pendulum swing. How do you address that pendulum swing when this war on terrorism has no end, proverbially? I just want to hear your comments on that. And then lastly, this is kind of a pop culture reference, but there was an episode in The West Wing, I'm a TV junkie, so excuse me, that made the analogy that Islamic extremists is to Islam as the KKK is to Christianity, in terms of the religious nationalism that you were talking about. Mm-hmm. Do you believe that analogy holds truth, or is there more subtleties to it? Sorry for the multiple questions, but thank you for your time.
Don't let him kid you on that Holder case question, though, because he wrote a paper about that. So.
Oh, okay.
Honors paper.
We're going to go through all
I think we should. I think we should hear some more. But thank you. We'll get back to them.
Brandon?
Yeah.
And whatever we don't answer here, we'll happy to talk after.
Let's go to this side. Get it.
Hi. I don't know if you can answer this question, but I'd like to hear your opinions. It just seems to me like the personnel that were appointed during the Obama administration sort of pulled a 180 on what they had advocated previously. Yes. And I just want to know what explains that. What is the driving impetus between, Harold Koh was one of the most vociferous critics of the Bush administration policies when he was at Yale, and then he went to the State Department and went the other way. Gregory Craig became White House counsel, but he couldn't get Guantanamo closed. Eric Holder was a judge. It just seems like all these people got appointed, and most of all the president, who was a constitutional lawyer, and now he's had like you wrote about. So I just wanted to know, what do you think drives that? Is it just the nature of institutions and their incentives? Is it the people and their individual failings?
I wrote an article about that, so I'm really excited to talk about that. Thanks for raising that.
Okay. Oh, Brandon?
Hi. I'm curious what the panel thinks about what we as ordinary Americans can do to affect culture change and kind of bring about a shift in public opinion. I think that's happening now. We don't see maybe as much of it here in blue California, although it's certainly a problem. But particularly in American culture broadly, how can we normalize relations between different American groups?
Okay, one last one.
I'll keep it simple. Do you guys consider the United States to be a police state? And then if not, how close to it do you think it is?
All right. I'm going to just answer the first question with a very simple yes. I think that Humanitarian Law Project went too far, and I'll just say that there is legislation now in Congress, HAFA, you should look at this bill, that is now proposing to allow humanitarian aid organizations free speech, ability to do peacemaking activities, to hand out blankets, food, water, to do all of those important activities that they are best at, and to make their own judgments because that they're on the ground and they know about who to associate with. So that's a very important piece of legislation to support if you're concerned about that issue.
A lot of questions. You want me to just go
Yes,
all of them?
whatever you want to take.
Okay.
How about we'll just take the questions that we're quick to answer now, and then and come talk to us afterwards about the.
I don't know if this applies to the Humanitarian Law Project, but I think that when we work to get groups to adopt nonviolent means of achieving their political objectives, that should be applauded, not made illegal. Terrorism is a highly politicized issue. You have many states now whose leaders were former terrorists or were on a terrorist list. You had Congress approving a law for Sinn Féin that allowed the political wing of the IRA to operate here in the United States, or to fundraise, I believe. I'm not sure what. You have the Congress basically supporting the Mujahideen al-Khalq, which was on the terrorist list, and then delisting them because of political affiliations, even though their behavior hasn't changed at all. So there are a lot of there's politics, there's policy, and the fact is we want people who have grievances to deal with these grievances in a way that does not lead them to self-destructive and violent behavior. And if we can get these groups that behave, or at least remove audiences or minimize their audiences, that is an effective counterterrorism strategy. But you say that in Washington and they say, oh, you're just an apologist for terrorists and so on and so forth. Number two, in terms of the KKK to Christianity, Al-Qaeda to, yes, I agree that that is a good way of describing that parallel. Everybody has their religious nationalists, or white supremacists, or so many groups today, or people that want to influence their government to go to war against countries, and in that way takes care of that excitement to see the other destroyed. So it comes in many shapes and sizes. A cultural change, yes, definitely we need that. For example, even Muslims. There was a Fort Hood shooting about a month ago. Guess what every Muslim was thinking? Oh, I hope it's not a Muslim. Mm-hmm. I pray this is not a Muslim. Even the country had a sigh of relief when it was not a Muslim. Oh, it was just somebody with post-traumatic stress disorder. Really? That's it? Still, people died. Mm-hmm. It was horrific. It was a violent act. But because one person said two words, Allahu Akbar, that made this an international crisis, not just a national crisis. And another person who came from Iraq as a war veteran had post-traumatic stress. It turns out most, if not all, terrorists have post-traumatic stress disorder. They are psychotic in one way or another. So we need to look at mental health, talk about cultural shift, and crime. When we deal with gang prevention, a lot of it has to do with mental health. And I learned that from Father Gregory Boyle, who's one of the best at dealing with those issues. But we need to normalize with relations. Number one, I agree with that. But more importantly, as I was telling my panelists, my co-panelists, there still needs to be an American Muslim narrative. American Muslim narrative, not just in counterterrorism. That's the only time you ask a Muslim for an opinion on TV. When, oh, we just bombed it. Well, why did that happen? I don't know. Well, what is it in your religion that makes people do that? It has not. So we need an American Muslim narrative that is measured by a common yardstick on how we measure Christian, Jewish, Buddhist. So that the aberrant behavior within Islam is seen in the same way as aberrant behavior within Christianity and Judaism. Along with the complexities of politics and quote-unquote Islam in the West. Just this idea, Islam in the West, is an artificial barrier. There's no such thing as Islam in the West. There's Islam in the West, there's the West that has been a part of Islam, but it is an artificial barrier that really means there's the Judeo-Christian West and then the Islamic East, as if Moses was born in the Bronx or Jesus was born in Paris. So it is a way to continue that divide and push it down people's throats. But however, seeing that in terms of a police state, as bad as things may be politically, I would still rather live here than live in Saudi Arabia or Iran or Egypt, because I can practice my religion freely in America. And that's what I want to preserve, and I want my children to grow up without having the false choice of being American or Muslim. I want them to be proud of both. And really that's what we're working for. And I think that will enrich and help develop that cultural shift to normalize the American Muslim narrative in our country.
On that incredibly positive note.
Sorry, Chris.
Oh, no.
Chris, did you?
Let me very quickly respond, because the questions were excellent. What Salam just said was very exciting as well. But let me get back about the pendulum swing. So I think the best model for presidential power is Abraham Lincoln. Lincoln during wartime said, there's emergency, there's civil war, I'm going to act, but I'm going to act within the rule of law. And I'm not sure there's been a pendulum swing. I think there's been a progressive move toward unlimited presidential power that goes back at least to Truman and arguably to Roosevelt as well. So I'm concerned about that. You're right, though. In the context of an unending war, it's even more dangerous. The question about all these people came in the Obama administration, Harold Koh, Marty Lederman, David Barron, who were critics of unrestrained presidential power. Why did they do a 180? I wrote an article about this. Probably 6 people have read it. It's in Presidential Studies Quarterly. So I'm really excited. By telling you all about this, I like 10 times so many people will hear about this.
Yeah, exactly.
No, but just the chance
But
to
now
mention
he's got
it.
a much bigger
But-
audience.
So I think that's absolutely right. And the best I can come up with, my article mainly shows that they changed their views and that it cannot be justified. They changed their views in ways not justifiable. I think the best answer is, again, I keep coming back to Mike. Excellent discussion. Mike said, if government gets power, it's not going to give it up. I think that's probably right. If you're president, if you're an executive branch lawyer, why are you going to surrender power? The last point Salam made, of course, I agree. Despite all these problems, sometimes I feel like, I'm attacking the United States. It's not. I don't think it's about being anti-American. I think it's about fulfilling American ideals. The United States can always do better. We should approach our ideals. The fact that we can talk about these things is really actually not a given throughout the world, and it's great that we can do this. I don't think the United States is a police state. I think there are serious problems. There are reasons to be concerned about, but I'm glad that we have the opportunity to talk about them.
Well, if anything, this is a seminar in civic responsibility, which my students know I talk about all the time. You have to be engaged. And we have been engaged all day long in an incredible conversation about this important topic. I want to thank these panelists. Salam, thank you so much. Thank you so much for coming on short notice. And Catherine and Chris, thank you for coming
thank
such
you.
a long distance.
Thank you.
We are officially adjourned. Thank you all so much.
So much.